Welcome back to Blue Collar Retirement. In this series, we talk about retirement in a way that's simple without complicated language. Today, we're going to talk about trust. This is one of those estate planning topics that a lot of people have heard about, but not everyone fully understands. Some assume trusts are only for the wealthy. Others think they're complicated or unnecessary. The reality is, trusts are simply legal tools. And like any tool, they can be very useful when used in the right situation. So let's break it down what a trust actually is, how it works, and the different types that people commonly use. Before I begin, it is important to state that I am not an attorney. I'm an estate paralegal from an American Bar Associated certified university program. Everything in this video is for educational purposes only. To determine what is the best choice for you and your family, please consult an attorney that works in estate planning. At its core, a trust is a legal contract. When a trust is created, it has been empowered to carry out specific actions now and in the future, as designed by the creator. The creator is generally titled the trustor. Other titles can be used for the creator of a trust. It could be the grantor or settler. A trust acts to hold assets for many different purposes. For example, a parent may use a trust to hold assets for their children. Another important person is the trustee. The trustee can be one or more people that may be able to work independently or be required to have all trustees to agree for a trust decision. This could also be an institution. The trustee or trustees are responsible for managing the trust according to its rules. Third is the beneficiary. That's the person who benefits from the assets inside the trust. This could be individuals, charities, or institutions. When you create a trust, you are essentially setting rules for how your assets will be managed and distributed, either during your lifetime or after your death or both. Trust can hold many different types of assets, like, for example, bank accounts, investments, real estates, and sometimes life insurance. The purpose of the trust determines how it's structured. Now, let's walk through some of the most common types of trust and how they function. A revocable trust, often called a living trust, is one of the most common types. As the name suggests, it can be changed or revoked during your lifetime. If you create a revocable trust, you typically act as the trustee while you're alive. That means you still control the assets. You can buy, sell, spend, or move money in and out of the trust as you wish. At any time, you can remove all of the assets and revoke it, take all of its control away. The main advantage of a revocable trust is that it allows assets to pass outside of probate when you pass away. Probate is the legal process that is done in a probate court. Each county in our country has a probate court. The purpose of this court is validating and assuring the distribution of your assets according to your wishes. It's an open process, and the records of this court are available to the public. Assets held in a properly funded revocable trust generally avoid that process, which can make things smoother for your family. The reason for avoiding the court is that with a trust, the trustor has created a succession plan. If the trustee passes away or resigns, a new trustee immediately takes control. It's important to understand that because you maintain control over a revocable trust, it does not protect assets from creditors, long term health issues, and it does not remove the assets from your taxable estate. It is primarily a tool for organization, control, and probate avoidance, not asset protection. An irrevocable trust. An irrevocable trust is different in one key way. Once it's established and funded, it generally cannot be changed or revoked easily. When you transfer assets into an irrevocable trust, you are giving up control of those assets. You cannot serve as the trustee. A trustee, who is not you, manages them according to the terms you set. Because you no longer own those assets in the same way, they may be protected from certain creditors and may not be counted as part of your taxable estate, depending on how the trust is structured. This type of trust is often used for asset protection, estate planning, or long term care planning. For example, one of my longtime clients went into a nursing home. She asked me to help to complete the paperwork to her entering that facility. She had an irrevocable trust for over a decade. Inside that trust, there was an account that was worth over $1 million. I did not list that asset on the entry paperwork. That account was removed from my client's control over 5 years ago and is now protected if her health continues to decline. However, the trade off is flexibility. Once the assets are inside an irrevocable trust, you cannot simply take them back. That's why careful planning and legal guidance are essential before creating one. There are some type of trusts that we don't see that often. For example, a special needs trust is designed to benefit someone with a disability without jeopardizing their eligibility for government benefits, such as supplemental security income or Medicaid. Many government programs have strict income and asset limits. If a person with special needs directly inherits money, it could disqualify them from receiving benefits. A properly structured special needs trust holds assets for that individual's benefit while keeping those assets separate for eligibility purposes. The trustee can use trust funds to pay for things that improve the beneficiary's quality of life: education, therapy, transportation, recreation, without replacing or interfering with government assistance. This type of trust can be created by parents, grandparents, or other family members who want to ensure long term support and care for a loved one with special needs. Another type of trust is a charitable remainder trust. It combines philanthropy with financial planning. In this arrangement, you transfer assets into a trust and retain the right to receive income from those assets for a period of time, often for the rest of your life. After that period ends, whatever remains in the trust goes to the designated charity. One potential advantage is that you may receive a charitable tax deduction when you fund the trust. Additionally, if you contribute appreciated assets such as stocks or real estate, the trust may be able to sell those assets without immediately triggering capital gains taxes in the same way an individual would. This type of trust can provide income, support a charitable cause, and offer certain tax planning opportunities. It's most appropriate for individuals who already have charitable intent and want to integrate that into their estate strategy. It is important to make sure that charity meets specific requirements outlined by the IRS. For example, this includes most charities that are designated as 501c3. There's another type, an irrevocable burial trust. It's specifically designed to set aside funds for funeral and burial expenses. Once established, the funds cannot be withdrawn for other purposes. The money is reserved solely to cover end of life costs. This type of trust is often used in Medicaid planning. In some cases, setting aside funds in an irrevocable burial trust allows an individual to prepay for funeral expenses without those funds counting against Medicaid asset limits. It provides peace of mind that final expenses are covered and reduces the financial burden on family members. Because the trust is irrevocable, the money cannot be reclaimed for other uses. It serves a very specific purpose, planning ahead for final arrangements. Trusts are not one size fits all solutions. They are tools used to solve specific desires and problems. Some are focused on avoiding probate, others are designed for tax efficiency, asset protection, charitable giving, or protecting a vulnerable loved one. It's also important to remember that a trust only works properly if it's funded. Creating the trust document alone is not enough. Assets must be retitled or transferred into the trust for it to function as intended. An unfunded trust does not accomplish its purpose. Trusts also work alongside other estate planning documents, such as a will, powers of attorney, and healthcare directives. Estate planning is most effective when all of these pieces are coordinated. Trusts are not just for the ultra wealthy, they are planning tools that provide structure, clarity, and control. Whether the goal is simplifying asset transfer, protecting family members, supporting a charity, planning for long term care, or setting aside funeral expenses, there is likely a trust structure designed for that purpose. The key is understanding what problem you are trying to solve. Once that's clear, the right type of trust becomes much easier to identify. And with any legal and financial strategy, decisions around trust should be made carefully and with proper professional guidance. But understanding how they work is the first step. In Blue Collar Retirement, we focus on practical education, breaking down topics that can feel overwhelming and making them understandable. Trust may sound complicated at first, but at their core, they are simply structured plans for how assets are managed and distributed according to your wishes. And when it comes to protecting what you've worked your whole life to build, having a clear plan in place really matters.